SJC-08768, Commonwealth v. James Anthony Martin.
Bolgen, good morning.
Good morning, Your Honor. May it please the Court, Claudia Bolgen for Mr. Martin. I would like to acknowledge my co-counsel, Willie Davis, who worked closely with me on this case until his death this summer. Your Honors, I'd like to begin with the issue of whether the Brown felony murder rule should be applied to Mr. Martin. This Court should consider whether federal law prevents a state court from narrowing criminal liability without applying that new rule to cases pending on direct appeal when the new rule was announced, as was Mr. Martin's case. The cases that I'd like to discuss today are Supreme Court cases in Fiore v. White and Bunkley v. Florida. Neither one of these cases has been interpreted by this court to date, and the issues presented in those cases are due process issues. And the reason that those cases are interesting with respect to this situation is that both of those cases involve the Supreme Court asking a state court when its law had changed. But the reference point for the operative time period was at the date the defendant's conviction became final.
Well, now, counsel, I understand your point, and you have a good argument, but statute of limitations, when a defendant is out of the jurisdiction, it's told, correct?
I would imagine so.
Right.
This case is certainly old, Your Honor.
Oh, yes, but so if it's told, well, the defendant is out of the jurisdiction, and the defendant's back in the jurisdiction, what time frame do we apply?
Okay.
Your Honor, in this case, it's been 43 years since the crime. No question.
Right, I'm sorry, but I think you may be referring to the Brownell case.
I'm sorry, do I have the wrong case?
So,
Oh.
right.
Oh, okay.
So that too was an old case, but with a different set of
I
regulations.
am so sorry.
Can I?
But why don't you
can I
answer
get
those
right
anyway?
to-
No, just-
Can I ask you about Fiore and Bunkley? Weren't both of those cases in which the law was being clarified and not being changed?
No, Your Honor. Fiore was the law that was being clarified. When the Pennsylvania Supreme Court got back to the U.S. Supreme Court, they said, no, actually, the law was always what it was. We just, made a mistake and didn't recognize it. The Florida court in Bunkley, the issue there was a change in what was called the common pocket knife exception. So when the Florida court originally got back to the U.S. Supreme Court, they were equivocal. They said, oh, that law has been changing for, quite a long time, but they didn't tell the Supreme Court what exactly the law was in 1989, which was the operative date, the date Mr. Bunkley's conviction became final.
I thought they're clarifying that pocket knives are not dangerous weapons. They're not changing the law. They're just clarifying what they meant by dangerous weapon, right?
I don't believe that is the way Bunkley should be read. In fact, with regard to a change or a
But he's convicted of being armed with a dangerous weapon. Here, a pocket knife. Florida law exempted pocket knives from being classified as dangerous weapons. But then the Florida court, basically clarified what that was. It seems like it's a case of clarification, right?
I would disagree with that because the common pocket knife exception in Florida, what the Florida Supreme Court actually said to the Supreme Court was, oh, that law has been evolving over time. So when I read Bunkley, I read it as a change case. But whether it's a change or a clarification may not make that much of a difference because the operative concept of Bunkley and Fiore is the date that the law is looked at with respect to a particular case. And that is the date that the defendant's conviction became final, which in our case hasn't happened yet. So that was a big deal in Bunkley and a big deal in Fiore because those cases were on collateral review. This case is on direct appeal. So whether it's a change or whether it's a clarification shouldn't make a difference. The operative issue is what was the law on the date Mr. Martin's conviction became final? Well, it hasn't yet, so that law would be Brown.
But we have said that the case would have been tried very differently had that been the law at the time, especially in this case where they could have proceeded with a finding malice in terms of the way the shooting occurred.
Well, interestingly, Your Honor, this case was tried in between Commonwealth versus Gordon Brown case in 1984, which happens to be the co-defendant, and Paulding. And the trial judge did actually instruct on second-degree murder. And the defense did actually request a manslaughter instruction, both voluntary and involuntary, which the judge denied. So it's difficult to see how in this particular case the prosecution could have tried it any differently.
I thought in this case they proceeded only on felony murder.
That is correct.
Right,
But-
so, I mean, and that's in part because when they did the Gordon Brown case, they was found guilty of second degree, and this, they could go, if they only charged felony murder, they would essentially be assured that if he committed the armed robbery under the common law at the time, he'd be guilty of first-degree murder. So they proceeded on the theory that they would never have, of course, proceeded upon if Brown had been the law at the time.
Granted, Your Honor, but that isn't the issue. The issue here is, was there a due process violation? Is it fair to hold the defendant to being convicted for life without parole of felony murder when the Commonwealth didn't prove malice? And the question of whether the prosecution is somehow impacted is rather secondary. There's many instances where this court has had to, quote unquote, clean up a big mess and result in many convictions being vacated that may not have, been this court's first choice. Justice is justice. It was unfair before Martin to hold defendants in prison for life for felony murder when malice wasn't proven as to them. And it's unfair for Mr. Martin, whose case was pending on direct appeal when Brown was decided. And so the issue is, this court said in Brown, well, this doesn't have any constitutional dimension. But the question is that really true? And if it's not true, then federal combination of due process and retroactivity law, when in its intersection, would demand that this court apply.
Didn't we say in Brown, and it was unanimous, that felony murder is constitutional?
Yes, felony murder was constitutional prior to the change in Brown, and it's constitutional now.
Right.
But again, that's not the issue. For that interesting issue, I would suggest that Your Honor look to a Nevada case, NICA versus Nevada. It's cited on page 64 of my brief. And in that case, what the Nevada court did is it changed the mens rea jury instruction and said and when it changed it, oh, this isn't a constitutional problem, we're not going to apply it retroactively at all. And then the Ninth Circuit came in and said, that's actually a due process problem. And what NICA is the Nevada State Supreme Court saying, our instruction before we changed it was constitutional. We changed it. It's better now, but we were in error to not apply it to the case before us and not apply it to cases pending on direct appeal because of the due process element.
Can I ask you a question? Is there other states have done away with the felony murder rule, have they?
I'm sorry, Your Honor?
Have other states done away with the felony murder rule?
Other states have.
What have they done in terms of retroactivity?
That's an excellent question, and that's one I didn't research. I would be happy to research that for Your Honor.
Good. Good.
I'll submit that. I'll submit that in terms of a 16L letter.
May not find as many states as you may think, but you're welcome, so.
We kind of looked.
Well,
We looked at that, yeah. So maybe some have followed Brown in the interim, so you're welcome to take a look at that. But I mean, we change jury instructions a lot.
exactly, and the point is jury instruction changes generally wouldn't be something this court would say, oh, this has a constitutional dimension. Oh, we have to think about whether we need to apply it retroactively to people whose cases are pending on direct appeal. But some changes do. Narrowing criminal liability is one of those changes. Both Fiore and Bunkley were that posture, narrowing criminal liability, and whether the cases pending on direct appeal, when that rule was narrowed, needed to have that rule apply to it. That's the interesting intersection of due process and retroactivity law that this case brings up.
I have a question beyond the brief. Why isn't there a second-degree felony murder here with the drug transaction?
Why isn't there a second-degree felony murder? The only predicate felony that the Commonwealth proceeded on.
Doesn't have to be charged, it didn't have to be charged.
Agreed, but the only, the Commonwealth chose to proceed in that way.
I appreciate that, but there was no request for a lesser included second-degree felony murder here.
Very good point. That may have been an ineffective assistance of counsel move
That's
on
why
behalf
I'm
of defense
asking.
counsel, which certainly under 33E, this court could recognize.
Can you do a 16-0 letter on
I would absolutely be delighted to do
Got a lot of
that.
homework here.
And one on the future case that I asked you about too.
I'm going to need my.
No, just kidding. No need to get
So
involved in other people's
let's
litigation.
Let's discuss, the defendant did seek an involuntary manslaughter instruction.
And a voluntary manslaughter instruction.
Right.
But the involuntary manslaughter speaks more directly to the defense, which was, this was a drug deal gone bad. There was a tussle over the gun, and a shot was fired. So the involuntary manslaughter instruction was erroneously denied, because in the light most favorable to the defense, there was evidence to support it. And that plays into the lack of, a lack of malice finding here to make this conviction not consonant with justice.
it? You're talking about the out-of-court statements that came in for all purposes.
Yes, there was a distant cousin, Nesbitt, who testified, and the Commonwealth certainly disputes that this was sufficient, but he testified the white guys had the gun. There was an accident in Cambridge. There was a drug deal gone bad.
Yeah, and your point is, it doesn't have any less weight when it came in for all purposes and sizing up in the light most favorable to the defendant, whether there's manslaughter instructions required.
This court's case law is clear on that.
Why is there prejudice where the jury found a felony murder? Because he would certainly not have been entitled to involuntary manslaughter on a finding of a felony murder.
You're referring to the Evans case, which generally says, yes, when you are charging felony murder, involuntary manslaughter isn't appropriate. But in Evans, there was no other alternative to felony murder at all in that case. And that was really the operative concept. Here, there was a legitimate alternative to felony murder. It's not a felony murder situation when a drug deal, a contemplated drug deal goes bad, someone is killed in the course of a drug deal. The issue in this case was it an armed robbery or was it a drug deal? And that was essentially the defense. It was a drug deal. Felony murder was inappropriate.
My question goes to whether or not there can be a finding of prejudice from the failure to give, let's assume for the sake of argument that it should have been given. Why should we find prejudice where the jury ultimately found him guilty of felony murder?
In this situation, there was no way for the jury to find anything lesser than what they found, because the way that the instruction came in on second-degree murder, the judge basically said, oh, well, this really, the Commonwealth is only proceeding on felony murder. And there was no way of the jury evaluating whether the conduct was lesser than malice. They never found malice. This jury never found malice at all. And they could have. They strike that. They never found malice, and maybe they could have looked at this situation and said, this is involuntary manslaughter. And so not giving the involuntary manslaughter instruction does prejudice the defendant, because otherwise...
Can you do that again? I don't follow how that works. Say that again. If he's convicted of felony murder...
He's convicted of felony murder.
They don't need to prove... And say we don't buy your argument that it's retroactive, so they don't need to prove malice. So how is they prejudiced by not getting a voluntary manslaughter instruction in that context if we don't agree with your retroactivity analysis?
Sure, because there was a second-degree murder instruction given at this trial. There is certainly case law that says, hey, if this is only a felony murder case, then any, voluntary manslaughter or anything having to do with malice, you can't help the defendant. But in this case, there was actually a second-degree murder instruction, which of course has malice as an element.
I thought the only indictment is for felony murder. There's
No
not-
question about that. This
And an
instruction
And
was,
the only instruction was felony murder.
no. There was a second-degree murder
You
instruction.
sure it wasn't a second-degree felony murder instruction?
No, this was given in the context of the time period between Commonwealth versus Gordon Brown and Commonwealth versus Paulding, where trial judges, this court told trial judges, well, the degree of murder is to be found by the jury. So under all circumstances, you have to give a second-degree murder instruction so that the degree of murder can be found by the jury.
You got an accident instruction as well, right?
He did. But
So after Paulding, he wouldn't be entitled to the second-degree murder nor the accident instruction.
True, but this case is still here to ask
But how
for
do
the
you get,
Brown
I guess,
instruction.
I understand the procedural posture and where you fit in, but there's no right to a second-degree murder instruction unless it's second-degree felony murder. So how does, if this were not a felony, you would be able to say involuntary manslaughter or even excessive force self-defense, sudden combat,
Yeah.
whatever it might be. But since it's a felony murder, you don't really have that. So how does the fact that they were instructed on second degree give you the opportunity to get down to voluntarily or involuntary manslaughter?
When Your Honor goes back and looks at the felony murder cases where defendants have asked for manslaughter instructions and have been denied because, hey, it was only felony murder, the issue there was, well, was there any other crime instructed that had malice as an element? And in this case, there was. And so that's why I'm hanging my hat on that, Your Honor, because that
Because
is the
back then-
situation. It wasn't only felony murder. If it was only felony murder, I see your point. But it wasn't, not in this particular case, under these unusual facts. If there are no further questions on that issue, I'd like to move to a very interesting issue in this case of ineffective assistance of counsel. And that is that there was a co-defendant in this case. His name was Gordon Kent Brown. And he was tried much earlier than Mr. Martin was. He was tried in 1984. So by the time of the trial in this case, 2001, he was up for parole. And what happened is that trial counsel for Mr. Martin went ahead in his opening statement and informed the jury that Gordon Brown would say this was an armed robbery, not a drug deal. The problem with that is that prior to counsel's opening statement, the prosecutor had demurred to the judge when the judge said, "Are you going to call Mr. Brown?" And the prosecutor was like, "Oh, strategically, he's available, but I don't know." And then the prosecutor opened.
Don't we have two other witnesses saying that this was an armed robbery?
The issue of there was one brother who testified, who was the surviving brother who was there, that described what happened.
Right.
But the issue here was whether it was a planned armed robbery or whether it was a drug deal, and that only Gordon Brown could have testified to as the co-venturer, as the co-defendant, and that never came up at all in the prosecutor's opening. So the prosecutor didn't open on Gordon Brown. He didn't say what only Gordon Brown could have said, that this was a planned armed robbery, right, not a drug deal. So despite that, the trial counsel got up and told the jury the worst possible fact, that Gordon Brown would say this was a planned armed robbery, not a drug deal, when he didn't have to. And the issue taken with what happened with the motion judge is that the motion judge didn't consider that trial counsel could have denigrated the credibility of this witness, could have dragged him up and down for all of the reasons of bias and things of this nature without telling the jury the worst possible fact. And that's what he should have done. And this was a big problem here because, of course, the defense was this was a drug deal gone bad, not an armed robbery.
Let's assume you're right, that the defense counsel should not have said that in opening. How do you prove the issue of prejudice, given the weight of the evidence here?
Again, this was a situation where The trial judge at sidebar said, hey, there's no evidence of an intentional killing here. He said that.
Yeah, I don't,
and-
that has to be a typo, but, I mean, it's hard to imagine, unless he was referring to the claim that it's not charged as a first degree. But in any event, I mean, it's hard to give much weight to that in view of the evidence that Mr. Paulson presented, which is that he just...
But with regard to there being a substantial likelihood of a miscarriage of justice here, looking at this case altogether, the way, what the defense was, the way it was tried, the instructions that were given, the instructions that were not given, whether the Brown felony murder change would have made a big difference in this case, I submit it would have. Taking that all together, there was a miscarriage of justice here. There was prejudice to the defendant, and I would ask on behalf of Mr. Martin that Your Honors either vacate his conviction, send it for a new trial, or consider lowering the burden of his conviction to second-degree murder.
Okay,
Thank you very much.
Mr. Ferriter.
Good morning, Your Honors. Timothy Ferriter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. And starting with the Brown retroactivity question, I think the operative question is whether there was a clarification in the law in Brown or a change in the law. As we see every day in this court and the appeals court, we continue to affirm the felony conviction of larceny over 250, because when there's a change in the law, it doesn't apply to defendants even on direct appeal. If the legislature had made the change that this court had made, there'd be no question that the presumption would be that it would be applied prospectively only and not retroactively. And I think this court clearly stated that the murder is a common law crime. The sentence is laid out the statute, but this court has repeatedly stated that the content and the elements of murder are laid out by this court in the common law. In this court, in this case, while the numbers were interesting in the decision overall, this court decided 7-0 that the felony murder law was constitutional, rejected the defendant's Article 12 claim, and upheld the conviction, but changed the common law prospectively and did so appropriately. And addressing Justice Lenk's question about other jurisdictions, I was glad I looked at this week. I noticed in the Chief Justice's concurrence that he cited to the Michigan case, People versus Aaron, where the Michigan Supreme Court did the same thing this court did and changed the felony murder rule in 1980. And in that case, they also did it prospectively only. Since 1980, the Michigan court has held to that, and the Sixth Circuit has continually accepted that change and not reversed any convictions on habeas. I can cite to Brown versus Foltz, 763 F2D 191 from the Sixth Circuit, and I'm happy to submit a 16.
Also Brown?
I'm sorry?
Also named Brown, did you say?
Bowen, sorry,
I'm sorry.
Bowen versus Foltz.
Bowen.
And I'm happy to submit a 16L letter with some of the Sixth Circuit authority, which has affirmed Michigan's prospective-only application since 1980 of the same change in the felony murder rule that this court made. And I think Fiore and Bunkley both state that it's a clarification of a law or a change in a law is a matter of the state courts to decide. And I think this court in Brown made a change in the law, and I think that's pretty obvious from the decision being that it was a 7-0 affirmance and then only a change in the common law based on the concurrence. Going to the manslaughter instruction, or the lack of a manslaughter instruction, the judge made his ruling, this is on volume 3, page 21, the judge correctly ruled that where the only theory of the prosecution is felony murder committed during attempted armed robbery, that a manslaughter instruction isn't warranted. This pretty much parrots this court's model jury instruction that manslaughter and the case law is not an option where the sole theory of the case is armed robbery. And the reason for that is to get to any of the manslaughters, excessive use of force in self-defense, sudden combat, or involuntary manslaughter on a recklessness theory, the jury would first have to find that an armed robbery hadn't been committed. If they find an armed robbery, you can't get voluntary manslaughter instruction. And that's why this court, in both its jury instructions and the case law, takes away manslaughter instructions where the sole theory of the case was felony murder.
Okay, but and that sounds right to me, but you're ahead of me. So their theory is it's not an armed robbery, but a drug deal gone bad.
Correct.
And that they're wrestling over the gun.
Correct.
And there is evidentiary support for that.
Correct.
Because of Nesbitt's testimony. But so they don't have to give them a voluntary manslaughter instruction in that context, because the jury sort of has an option to,
If the jury found that they were wrestling over a gun because the drug deal went bad, they would have meant that it was not an armed robbery, and therefore they couldn't have convicted him of first-degree murder. The judge was very explicit in his instructions that in order to convict the defendant, you have to find it was a death during the course of an attempted armed robbery. Anything else would have been a not guilty. So that's why the element of malice was presumed, so there's no mitigation question here that would take it down to manslaughter. And the court was correct in ruling that manslaughter, because the sole theory was attempted armed robbery, was not an appropriate instruction, because that was not the element in dispute.
That sounds right to me, too, but I think the argument is, well, for, at that period of time, you could get a second-degree instruction.
Correct.
And whether or not the second, since you had a second-degree instruction and the degree of murder is decided by the jury, whether, when there is a second-degree instruction, if there's evidence in light most favorable to the defendant for manslaughter, whether or not you get a manslaughter instruction. I think that's the argument.
Yes, and I believe, Commonwealth versus Evans is from 1983, and I believe that's between the period where second-degree murder was mandatory, and they rule, and this court ruled in that case where felony murder rule applies generally to the defendant is not entitled to instruction on manslaughter. And I would say in this case, the second-degree murder instruction was given because it was required, and only because it was required. I don't think either side argued it in terms of finding one of the prongs that would lead to a second-degree murder case. The only theory of the case was felony murder, and the instruction was given just because it was obligatory at the time. If this case was tried a year later, he wouldn't have actually gotten any instruction except for first-degree murder, because this was tried 1 year before Paulding.
If in light most favorable to the defendant, it was a drug deal gone bad,
It was a not guilty,
well, why wouldn't?
if the jury found that.
what about excessive force in self-defense? Voluntary manslaughter?
There are very rare situations where you have an attempted armed robbery and you can get a self-defense instruction. It has to be something like an escape, which there are certain scenarios which the evidence does not support at all in this case.
But again, their theory is that it's not an armed robbery, but rather there's a drug deal going on, but it blows up somehow.
Yep.
And then they're fighting over the gun, and then he shoots him, or I don't know, they both, this thing with Nesbitt is hard to, it's hard to flesh out.
I agree.
But, go ahead.
Should there have been a second-degree felony murder instruction?
I think the defendant didn't ask for it in this case because he was looking for a complete not guilty, which he would have got if they believed it was a drug deal gone bad, because the jury was very thoroughly instructed you have to find an armed robbery, so I think it was an attempt to get a not guilty completely. It could have been, there could have been a theory if the defendant wanted it, but he didn't ask for it. But he was instructed, second-degree murder was instructed.
But again, I don't mean to belabor this, I just don't understand it. So if this were a drug deal that blows up, and that was an option for the jury to find,
Correct.
they're not entitled to an instruction on voluntary manslaughter, even though the elements of voluntary manslaughter are present.
Correct, because it would have been, under the theory, under the case as it was tried, it was only tried as an armed robbery. If they find it's anything else, they would have had to have found him not guilty. If they did not find it was an attempted armed robbery. So if it was a drug deal gone bad, which was argued, they were arguing for not guilty. So that was the Commonwealth's only theory. We didn't move on any other theory of first-degree murder. And as to Nesbitt's testimony in particular, even in the light most favorable of the defendant, there wasn't enough to get a manslaughter instruction. I pointed the court to Commonwealth versus Gonzalez, 465 Mass 672, which was cited in the briefing, where that's another case where the defendant didn't testify, but he told the police officers that he was jumped and that he was only defending himself. And this court found that those statements weren't enough to get a voluntary manslaughter instruction, where they were too vague. And I think this is a case where you have very vague statements where any self-defense theory would be based on testimony that was very similar, that something vague happened at the apartment and the jury would be forced to kind of completely speculate. Then moving on to the opening statement, I think I'd ask that you find the motion judge correctly found that the defendant, defense counsel was neither manifestly unreasonable in his opening statement or prejudicial to the defendant. In this case, excuse me, the defense counsel's strategy in opening was very clear. He was going to try to discredit all three main witnesses before they even had the chance to testify. I think he did so pretty well, particularly with Mr. Brown. It was not in his control whether Mr. Brown was going to be called to testify or not. That was up to the Commonwealth. But he didn't promise any exculpatory evidence, or he didn't promise a defense that didn't materialize. Rather, he just previewed his impeachment evidence.
Well, he didn't just preview his impeachment evidence, as Ms. Bolgen said. With Mr. Brown, he didn't just marshal the impeachment evidence, but he testified to that he's going to testify it's an armed robbery.
Well,
Isn't the appellant right that you didn't have to do that in the opening?
He didn't have to, but I don't think it was manifestly unreasonable. And looking at the whole statement regarding Mr. Brown, it's 90% about the impeachment. And the last sentence is, he knew that he meant to say Richard Paulson had the police, had told the police that it was an armed robbery and not a drug deal. He knew he had to agree with that story in order to get parole. It was the same theory for all three witnesses. They're all going to agree with what the Commonwealth just said in their opening, but they're all not credible, and this is the reason why. And I would say, in this case, the prejudice fell more to the Commonwealth than it did to the defendant. In the typical case, you see the defense counsel promising that the defendant's going to testify, and that doesn't materialize. And in Commonwealth versus Duran, this court has said that the prejudice comes to the defendant because the jury's going to believe that his testimony can't stand up to being under oath and cross-examination. In this case, I think the jury would have found that the Commonwealth had a key witness who the Commonwealth had made a deal with, but we didn't feel fit to call to testify because he wouldn't be able to be cross-examined or testify under oath. So I think in this case, it was neither manifestly unreasonable, where he had good reason to believe that Mr. Brown would testify, and it wasn't prejudicial. If there are no further questions,
Okay.
I'll rest my brief. Thank you.